So, we will approach now the last panel, and I think it fits quite good in our program right now. So, in this morning we started with the capital markets, so we learned what's available. In the second panel, we learned how to buy it. The third one was how to monitor it, and I think the fourth one is how it can go wrong. So, as my duty is today to introduce the moderator, it's an honor to introduce now the moderator for the last panel. She is the president, in Austrian terms, president of the German Shareholder Association, the DSW, and the president, I think, of Better Finance as well. Yeah, I think right. You're my president then at Better Finance. And a warmly welcome for Jella Benner-Heinacher. The floor is yours.
Thank you very much, Florian, for this kind introduction. And also, thank you very much for giving me the opportunity to moderate this last panel of today. I know it's tough to stick with us, but I'm sure you will get some interesting insights in some of the legal problems we have, or the legal solutions, I should better say. Well, we heard a lot this afternoon about sustainability reporting standards, about Ukraine investment, gold investment. I think we should go back to the basics and talk about what can we do via legal actions with respect to environmental, social, and government issues. So, first of all, let me take the chance and introduce my really wonderful panel. Let me start, first of all, with a person you probably know the most, Guillaume Prasch. As you know, he is the founder of Better Finance. He was 14 years managing director of Better Finance, his baby, more or less, as we say. And of course, he is an expert in every EU issues, but especially with respect to collective redress. So, Guillaume. Secondly, Eric, you're already standing there, so I take you. Let me introduce Eric Breiteneder. He is the local, he's a lawyer here in Vienna, probably also well known to the audience. He is an attorney, but also responsible for mass claims. I think Wirecard, Meinl, I think is another case, and Dieselgate. Yeah, so he will tell us a little bit about Wirecard later. So welcome, Eric. Then I would like to introduce from the Netherlands, it's always difficult for me to say the name in the right way, Quirin Bongartz. He allows me to say Q because it's easier. So welcome to Q is, of course, a very experienced lawyer in the Netherlands, and as you know, and we will discuss about this, they have the system of foundations and investor claims, and he is very experienced. He was also advising, I think, in the cases of Fortis and Steinhoff, and you will tell us a little bit about the Airbus case, because this is also a very current case. So welcome, Q. Yes, and we still have two left. I just see only one here. Okay, we have Anatoly von der Krantz, also, I think, Dutch, but he is here today as, actually, I will take a little bit. Anatoly, he will represent the US class actions and give us an insight in what is happening in the US, because he stands here as an attorney for Bernstein, Litowitz and Partners, and I think it will be quite interesting to get an insight in the US, so please welcome Anatoly. And last but not least, we should not forget about our Swiss colleague. It's a little bit Okay, so let us welcome Dr. Arik Röschke. He is not an attorney, for a change. He is a has management education, but he is the founder of the Swiss Investor Protection Association, SASV, right? Okay, and he is general secretary. And this organization, if I understand it right, was also founded for the case of the takeover of Credit Suisse by UBS. And he will give us an insight in what was happening in Switzerland and what is still going on. So please, welcome him too. Well, of course, you might think legal actions and ESG, what has that to do with each other? It's not obvious, to be very honest, and but I think there were already a lot of cases where the impact is obvious. Think of the climate activist that sued the Shell company a few years ago, and they won the case, at least in the first instance, in the Netherlands. And this has an influence, obviously, and that's what we are talking about. And I think it is really worth to look into the details how we can really impact environmental, social, and governance issues. And Anatoly, I would like to start with you, because you have to leave earlier, but nevertheless, we actually always look a little bit enviously to the US at their class actions. I'm a lawyer myself, and I'm quite impressed what you can reach in the US via these class actions. I mean, first of all, you don't have a cost risk because you have these contingency fees. You have a discovery procedure, which is much better than any procedure I know from Germany, for example. And finally, at the end, if the case is successful, you have quite high compensation payments, also not known in this dimension in Europe. So we look enviously to the US, and maybe you can give us or explain us some cases, or one case at least, where you have a class action which really had an impact on ESG issues. The floor is yours, Anatoly.
Thanks so much, Jella. And it's really a pleasure being here. I am based in the Netherlands, in Amsterdam, but I do work for a US law firm, and it is a privilege to show a little bit of a US perspective, because I think Europe and the United States are slowly, very slowly, growing towards each other regarding the ability of shareholders to recover losses and to improve ESG. So let me give you a future perspective of how it may look like in 20 years, if we are speedy. Because what I see in America, in the United States, is two types of actions. Class actions, really focused on the recovery of losses, and derivative cases. And I will give two good examples of both actions. First, class actions. Class actions are really focused on recovering of fraud-related losses. So, and this is actually quite significant. Over the last 20 years, $140 billion have been recovered through by shareholders through those class actions. So it's really significant. And if you take as a good example would be the Wells Fargo case. You may remember that Wells Fargo employees were opening fake bank accounts, and they would receive a personal bonus. And this did not happen a few times. No, there were 3 million fake bank accounts opened. And Wells Fargo was making good shine with all those new customers. So the stock price went up, and when the truth was revealed that all those bank accounts were fake, the stock price obviously dropped. and $7 billion was vaporized by the market. My client, a Swedish Handelsbanken, a Swedish fund, they were interested in leading the case. They had a significant loss, and they led this case. Long story short, we settled this case for $1 billion. So really significant recovery. And that is what you can do with class actions, really to recover losses. This whole process took 3 years. So in 3 years, from start to end, you have your losses back. So that is a real good example of monetary compensation. Not ESG, but monetary compensation. If we now look at the other type of action, which is fiduciary duty actions, that's where you actually step in the shoes of a company and you say, hey, board of directors, you have an obligation to be a fiduciary towards me, towards the shareholder. And if you don't do that rightful, then you can sue the same board. A good example here is the 21st Century Fox case. You all know this company from all the movies, but 5 years ago, with the start of #MeToo, there was a case of Gretchen Coulson, who was sexually harassed by Roger Ailes. And we investigated this case, and it turned out that this was not just a single matter of sexual harassment, but we could show a pattern of at least a decade of sexual harassment and also racial discrimination. People with a color were just not promoted. So, and then after 10 years, after showing this pattern, it does become a shareholder issue, because then you, as a board, do not provide a safe working environment, and you do not protect women and minorities, and you do not give equal opportunities for your employees. So we brought this case, which actually was a very small shareholder having some shares, and just having some shares would be enough to bring such a lawsuit. And we settled this case for $150 million, but in the meantime, we also created a board committee. And this board committee was authorized to issue all kind of guidelines, really focused on promoting a corporate culture that allows for a safe working environment. My client was allowed also to appoint the members on this board, and we hired Barbara Jones, and she used to be responsible in the US Army for the gay and lesbian emancipation. So she knows how to change a corporate culture. And that's exactly what she did at 21st Century Fox. We are now 5 years further, and I see, and we have broadened all the reporting mechanisms. We see a much lower number of sexual harassment, and also people with a color have been promoted. So I do think this has been a very effective way of changing corporate culture. In fact, other investors are now pointing at 21st Century Fox and towards other media companies and saying, hey, this board, this ethical board is becoming an example, a best case, a best practice. So Disney and other media corporations are also integrating this. So these are like 2 good examples what you can do in the United States with litigation to pursue, to demand better ESG.
Thanks a lot, and I think it's quite impressive to hear what was going on. Before I turn to Eric to discuss the Wirecard case, let me take the chance, since you are still here, to take a look a little bit on the current situation in the US. I mean, we were talking about ESG and what you reached in the 21st Century Fox case, but we also hear that in the US we have counter movements to ESG. we hear from several US states like Arizona who say, no, we don't want the pension money to be invested in ESG. We want it to be invested in the oil and in the gas industry, because that's where the profit is. And then we hear Larry Fink, the CEO of BlackRock, and he says, I will not use the word ESG again in the future. So, I mean, what is happening in the US with ESG? Do we have to fear that this will swap over to Europe? Maybe you can explain a little bit from your side the situation and the current notion of the US.
Yeah, so ESG actually is a container term, right? It contains hundreds of different policies, hundreds of different elements. And I think most parties from left to right, most people from left to right, all agree that good governance is a good thing, like controls, checks and controls. But there are other elements of ESG which are much more controversial, like, for instance, LGBT rights or climate change, because not everyone, I say, is convinced that of the human influence on climate change, and that's where it becomes so much more political. And I think investors have to, and also what you see in the United States is that investors have been using litigation really to push for governance reforms, because that is not controversial, and also for well, sexual harassment, racial discrimination, the S type of cases. But the E, the environmental type of cases, are very hard to bring, because it's more of a business decision, whether or not to externalize negative externalities. So it really varies. I do think it's becoming more political also in Europe, because the United States is in many aspects a few years ahead. So this is not a very positive outreach.
Yeah. Thanks a lot for your estimation. Thank you. If you have any questions, by the way, from the audience, please go ahead and just raise your hand. And yeah, we have one question. Do we have a microphone, by the way? No?
You were speaking about the recovery of losses for shareholders through class action suits. Another instrument that is coming over from the US more and more to Europe, the implementation of clawback provisions as an instrument to recover amounts paid to executives. I was wondering, what is your insight on these provisions and how substantial these provisions really are in the regular practice then?
Yeah, that's an excellent example. Clawback provisions are some of the provisions we usually demand when we are settling a case, because our clients not only want to recover losses, but also to prevent this happening in the future again. So clawback provisions are very effective, also in Europe. I do think we have a different culture in Europe than in the United States. If you invest in the United States, you also accept that you are investing in a different culture, and this culture means that you can only change a company by suing them. And in Europe, we have more a dialogue, and I think we are pretty successful in setting up this dialogue. So the instrument of shareholder engagement, shareholder dialogue is much more effective in Europe than it is in the United States. In fact, that's also, then I really need to go, but it's a really nice story. I used to work at one of the largest Dutch asset managers, and this was in 2010. Shareholder and responsible investment was all in this child shoes. And I was reaching out to Bridgestone, a Japanese tire manufacturer, because we had many concerns about the environmental effects of the tire industry, and also child labor. So I went to Japan for 3 times, had meetings with the board, and after the 3rd meeting, we agreed on a zero tolerance policy. So 40 children are now, well, freed from child labor, just by using the strength of capital. And so you can do great things with engagement, I think, outside the United States, not inside the United States. Then you really need to use the tool of litigation.
Very interesting. Thank you, Anatoly, for your insight. Eric, I think Wirecard, I mean, I'm here as a German, so when we talk about Wirecard, of course, it's first of all a German problem, I would say, because the bankruptcy of Wirecard hit us strongly in Germany. I think it was one of the biggest economic scandals we had. The damages exceed 1.5 billion euros. So, and we had a lot of, since it was a DAX company, of course we have a lot of investors, retail investors, that all owned Wirecard shares. And of course, as I represent the German Shareholder Association, we founded an initiative for the Wirecard shareholders, and we started with the Capmoc proceedings, and I know Guillaume loves the Capmoc. The German Capmoc is kind of where you can really bundle certain legal actions, and it is supposed to do the whole procedure a little bit more efficient. But the reality in our everyday life is that it is not the case. You know, the last Capmoc procedure, I think, was Deutsche Telekom, when we sued them. I think it's now 10, 20 years ago, and now we reached a settlement. So we're not talking about 3 years, like in the US. We are talking about inefficient, long legal procedures where you, as a shareholder, have the cost risk, and you also have, in case of a loss, you will all have to pay all. So the completely different situation. And of course, we initiated the proceedings in Germany and then went to the Netherlands, because the Netherlands is a little bit the paradise for the European investors. And we founded a foundation of Wirecard with the goal, actually, to maybe one day settle with EY Global. That's the idea. But Eric, you know much more from the legal side, and please give us some more details on the Wirecard case.
Yeah, thank you, Jella, for the kind introduction. And thank you also for the great organization of this Congress. I think it's a very, very interesting panels I witnessed today. Your introduction, including Wirecard, Mandel, Volkswagen, seems to me like I'm in the business of a crime scene cleaner and not having the right tools. Because when you hear about the American situation, then we have to say we are far behind of an effective collective redress system. So, and here comes, I really want to ask the audience at that stage, don't worry, it's nothing that you can say right or wrong, but I'm always doing this in these situations when I'm talking about collective redress to show the differences between America and Europe. So if you allow me, I want to pop one question. Who already lost something through a fraudulent behavior from an issuer of shares or bonds? Okay, that's fair. And second question, what are you willing to invest in the procurement of the claim? Or do you more think it is throwing good money after the bad money? So who thinks it's throwing good money after the bad money? Yeah, thank you. Because if the turnout would be others, I could not continue my thought. So that's exactly the result. We have in Europe a culture where procuring a claim is expensive. You need to engage lawyers. You need to go to court. You have lengthy proceedings that take, in Austria, 2 to 3, maybe 4 years. In Germany, 10 years, more than this. We don't know. So there are even jurisdictions which are less effective. So it takes a long time. It is uncertain, the outcome, and it is expensive. It's a risk for investors. And I think what the Americans did well is simply implementing a system which works very fast. My favorite example is the Volkswagen case. In 2015, the manipulations were discovered. In 2016, they already had a settlement, a very large one, where to compare numbers, in whole US, we're talking about 500,000 cars. That's almost the same amount, 380,000 cars, that we had in Austria, having the same engine, having the same manipulation. Recently, I can't bitch about the Austrian courts. I think we are effective in the environment given. So we have now breakthrough decisions where we are getting close to a situation where the Supreme Court says, and this is for me a very important development, says it should be the perpetrator who causes a damage should feel it. The damage refund is not only anymore a comparison between how are your values before the event and after. It is actually saying something like a punitive damage. It needs to be felt. So to avoid such a behavior in the future, I think it's a great development because it makes our job much easier. So coming to Wirecard. Wirecard is a perfect example by Anatoly. Wirecard is a perfect example. What we heard about today in the other panels, we actually heard about regulations, we heard about financial reporting. In Wirecard, the minimum standards, like KPMG said, were not fulfilled. So the fraudulent behavior that caused a damage to a great group of investors could have been discovered if the auditor would have applied standard proceedings. So where's the refund? Where do we get in court proceedings? We are doing court proceedings about it. The questions that are asked by the judges is, did you read the check and balances? And a certain enormous amount of investors say, well, no, but we read the analysis, we read the reports about it, and there was nothing in it. So as a matter of fact, we have a lot of regulations, but when it comes to the point that companies are not applying to that, then the sanctions and the damage refund is a very tough way to go. So I'm very happy to also cooperate with the Stichting Wirecard Investors Claim, because they are using basically a Dutch tool to not only collect the injured parties, but also facilitate a court proceeding in Germany with an assignment model and procuring the claims. And I think this is something that most from my profession forget about. We need to also facilitate for the perpetrator a way out of this. So a settlement proceeding that could be cleaning up and bringing total peace. So maybe a quick word, but I have a Dutch colleague here who may interrupt me when I'm wrong. But I think we see a development in the Dutch proceedings when it comes to a WCAM. So when we can declare a settlement binding, we see that it is very important to apply the Dutch claim code, which is like a compliance regulation, a compliance rule, which should, the Dutch foundation should be an objective foundation with an objective board, and it is very important to apply the Dutch claim code, to have, I think, two things. First, not only a representation of injured parties. I think this is one of the greatest things of the Dutch system. It's not a representing of individuals, it's a representation of interest. And interest can only be represented, such as DSW or Better Finance, when you have people involved that are not getting a personal gain out of representing an interest group. So it gives objectivity. That is very important, for me, the most important part of the Dutch system. And I think the latest Airbus decision points exactly on that and says we need to take care what we are developing on collective redress in Europe. It can't be a copy of what we see in the US. We have to make it better, I think. And that's why it is a very important development for me, the Airbus case.
So
yeah.
maybe let's
Yeah,
give
exactly.
you the chance to present the Airbus case. And of course, he is the expert in the Dutch law. We are not. And I think it is worth trying to explain to us what is the difference between the old legal situation with the WAMC and now with the new legal situation with WAMCA, because it's kind of difficult to understand. And of course, we all look at the Netherlands and how you develop, because you are actually in Europe the only possibility where we can find a settlement, a good way to find a settlement with the company. So please, Q.
Yeah, well, thank you very much for having me in this wonderful place. Yesterday evening I was at the Liechtensteinstrasse and I walked through the park where actually the princes of Liechtenstein still have two of their palaces, and this one used to be one of their domiciles, but they no longer have it. So the Liechtenstein family and their story is a bit of a background of my visit to Vienna. And I think actually, before I jump into the Dutch class action legislation, it's also worth mentioning that the Liechtenstein family actually know everything about losing almost everything you have, because after the Second World War, much of their possessions in Eastern Europe, especially in the Czech Republic, were confiscated by the then communist government. And then later on, in the second part of the 20th century, they managed to rebuild and restore much of their wealth because of their wealth management company based in Liechtenstein, the LGT. So they know everything about losing almost everything and gaining much back. So that is another reason why this is a very appropriate accommodation. But now let's jump into the Netherlands. We used to have a system which was used for decades and which is entirely based on a representative organization, which can be a foundation or an association, which then claims for declaratory relief. It couldn't claim for damages. It was only a declaratory relief, and in practice, once there was a declaratory judgment, defendants often settled with the claimants. However, that was always uncertain, and as we used to say, that particular claimant organization didn't really have the powers to really bring the defendant to the negotiation table. And then in 2005, there was the introduction of this WCAM, which is essentially a collective settlement act. And it's a very funny type of procedures. The claimants and the defendants first come to a settlement, and then they submit the settlement to the Amsterdam Court of Appeal for approval. And following that approval, it's a judgment. And therefore, by virtue of the Brussels 1bis regulation, it can be recognized and enforced in the entire European Union, except for a few exceptions. I'll not get into that. So that is what we got then. And then actually that type of proceedings was used a couple of times to settle securities cases. And most notably the Shell oil reserves case, the Converium case, and quite recently the Fortis case, which is until now the biggest security settlement in European history. And then there was the third And then the new legislation, which was effected on the 1st of January 2020, which is often referred to as WAMKA, which is essentially just a Dutch abbreviation of the name of the law, but that is actually the introduction of the first true class action legislation in the Netherlands. And now claimant organizations can actually sue for damages. So they cannot just get a declaratory relief, they can actually really get a judgment on damages which can be enforced in the interest of the victims. So that makes the whole system whole. But what we now see is that this new legislation is being used by claimant organizations, and the courts sort of need to reinvent everything that they have done. And this leads to a sort of patchwork of different types of judgments. So one panel in the Amsterdam District Court can take this direction, the other panel can take another direction, and the Hague District Court recently, in the Airbus case, which Erik already mentioned, took another disastrous direction, and I can say it's disastrous because I'm one of the counsel in the case, and we lost it on admissibility grounds, and we will not leave the case as it is, but for the time being, it is a very ugly judgment because it contains certain observations regarding the functioning of claimant representatives, and I disagree with Erik that what happened in that decision is a good thing. But we may get to that, but I should maybe be able to imagine, I do not really like to comment on my own cases, but there are a couple
But maybe
of things
you can, just for the audience, can very briefly say what it was about in the Airbus case.
Yes, I can.
So we know.
Yes, of course. Because the Airbus case is actually a quite shocking case. I think it fits in the story of the typical securities actions as we have seen in the Netherlands. There's always a governance failure. When it was Fortis, it was about the company's exposure to subprime mortgages in the US, which was ill-reported. And then we had, the Shell oil reserves, that was also a reporting issue, so essentially lack of governance oversight. Steinhoff was about the board cooking the books, and Airbus was just accepting that a significant part of the company was involved in mass-scale bribery all over the world. And this bribery department based in France had an annual budget of 300 million euros, and they kept on going for years. And then sometime in 2014, the company probably discovered that something was rotten. And then they started taking actions, and then ultimately first the British, then the French, and then the US authorities started prosecution, and then after a couple of years of prosecution and obviously negotiations between the prosecuting agencies and the company, it settled for a staggering 3.4 billion euros, which is one of the biggest settlements of its kind. But now shareholders have lost, the company is profitable, but each time there were announcements about the corrupt behavior of the company, there were visible stock drops, and we took action in that regard, and so did some other groups. There has been a very small settlement in the US, but that was only for US ADRs, which formed only a single-digit percentage of securities traded. So that's where we currently are.
Thanks a lot, Q. I think we will come back later and discuss the consequences of this court decision, if you want. I think we should give our Swiss colleague also the chance to say something. And you all remember spring of this year when everybody discussed in the news the takeover of Credit Suisse by UBS. That was not a small thing. It was quite a threat to the European banking system altogether. So everybody was looking at Switzerland. And of course, when we see, and that's the main issue, I think, when we see that UBS paid only 3 billion euros to the Credit Suisse shareholders, and at the last trading day, I think it was traded altogether at 7 billion Swiss francs, then actually we do not wonder that the Credit Suisse shareholders were disappointed by the exchange ratio. And Arik, I think it would be extremely interesting if you could tell us a little bit what your association started and what is it based on, because we don't know this legal background. And maybe you can also say something whether shareholders can still join or not, please.
Sure, thank you. So the association was founded 3 years ago because we saw some misbehavior in another company, and then one of the biggest shareholders initiated the SISV. And then when the Credit Suisse case came up in March 19, some of the shareholders were aware of us, and that's why they approached us, and if we couldn't do anything for them. But as in Germany and here in Austria, there are no real class actions available in Switzerland as well. So there's not much to say about class actions in Switzerland. There is a debate going on for several years, but as of now, there is no such thing planned like in the US. Nonetheless, on August 14th this year, we filed a complaint with now 1,500 former Credit Suisse shareholders. Some of them are UBS shareholders, some of them sold their shares, in order to review the purchase price. Because there's a special law in Switzerland, if there's a merger, you can ask a judge to review the purchase price, whether it was adequate or not. And in your introduction, you said already UBS paid only 3 billion, so that's why we think it's appropriate to ask for a review. Quick history about the case and Credit Suisse. In the opening speech of Camille Desnoyers, he emphasized the importance of banking and capital markets in order to create also infrastructure, and that was also the why Credit Suisse has been established in order to finance the infrastructure, in particular the tunnels in Switzerland, which probably every one of us has already used once to go to Italy, and also for the railways. So the bank is very attached also to Swiss history, and that's why it's important also for the Swiss people, and everybody in Switzerland is very interested in the case. However, recently, Credit Suisse was involved in several financial scandals where they made losses, such as the Greensill Bank, here also in Germany, which increased the pressure on Credit Suisse, and they lost trust, so people withdraw their money from Credit Suisse. However, the capitalization of Credit Suisse was always very good, and this was also approved by FINMA, the Financial Market Authority of Switzerland, and the Swiss National Bank. So it was more a crisis of trust than a crisis of liquidity. And just 4 days before the merger, so same week, the Saudi National Bank, which was the biggest shareholder in Credit Suisse, ruled out a capital increase, as it would have otherwise have held more than 10% of the shares. And that caused Swiss National Bank and FINMA to inform via press releases that the turbulences in the US do not cause any harm for the banks in Switzerland and for the financial market there. And they also said only a few days before the merger that Credit Suisse met the capital and liquidity requirements for systemically important banks. So this was a very important information for some investors who then bought also some shares. And the SNB said they would provide further liquidity for Credit Suisse if necessary. However, last trading day, 17th of March, there were already rumors in the market that there might be a bank run and there might be a forced merger between Credit Suisse and UBS. And then only 2 days later, on the Sunday, there was a takeover of Credit Suisse by UBS for these mentioned 3 billion. However, the process wasn't transparent, so we got like all of us, we got the news from I think it was Financial Times and others who spread some information, but it was not a transparent process how they came up with the price. So that's why various shareholders approached us, and we filed, as I said, this lawsuit under Article 105 of the Swiss Merger Act to ask for this appropriate compensation. And I quickly want to talk about the arguments in the complaint, because what was important that almost all control mechanisms in the Merger Act were repealed by an emergency ordinance from the Swiss government. And the price was not reviewed in advance, neither by UBS or Credit Suisse shareholders. And they were also not asked to vote if they accept the merger or not. And we also couldn't find any expert opinion about the price. However, the possibility to file a complaint under this 105 Swiss Merger Act was not exempted from politics. So this was very positive for us, because we saw that how they came up with the price was detached from valuation criteria, which we all, or some of us, learned at the university. So we identified 8 points why the price is significantly too low. I quickly go through them. First was net asset value announced by Credit Suisse end of March, which was 13.7 Swiss francs compared to those 0.76, which they only received. The share price, as you said, on Friday, just before the merger, was 1.86. And in the share price, the synergy effects are not reflected, which accounts for about, as you said, 8 billion Swiss francs. Then the 16 billion write-off of the 81 bonds is also not reflected in the share price before the merger. Then, according to press releases that we saw, Saudi National Bank on the same day as the merger took place wanted to invest 5 billion in new share capital for 30% of Credit Suisse. So this reflects a price of 16.7 billion compared to the just 3 that have been paid. And analysts of Morningstar, they valued Credit Suisse as 19 billion francs. So we have this range of the 3 billion paid, all the numbers after, up until the 19 billion. And also, if you look at the share price of UBS, so the investors in UBS can be very happy. Share price rose significantly after the merger, which for us, of course, is another indicator that the price was way too low. Shortly after, also UBS reported a record-breaking 29 billion profit in its second quarter, which is the biggest quarterly profit in banking history. So this has never happened before. So billion, not million. And lastly, UBS announced that provisions for legal disputes in the amount of 4 billion have been made. And now it's up to the court to decide whether the price was appropriate or not. And UBS was given until December 15 in order to respond to our claim. And as you in your introduction, you asked whether it's still possible to join. Yes, as of now, it's still possible to join. We say until there are no talks with UBS or until we don't have any answer, it's still possible to join our class action.
Okay, well, that's the good news. Thank you, Arik. Guillaume, 14 years of managing director of Better Finance. You experienced all these US class actions, but also the Dutch foundations, with Shell, Fortis, and so on. We were also involved. What is happening in the EU? Why isn't it possible to have a European class action to give the same protection to the European shareholders as we see it in the US? And ladies and gentlemen, when we go to Brussels, we don't even dare to use the word class action. We only talk about collective redress. so that they are not, deterred already. So Guillaume, what is happening in Europe, and why is it so difficult to get these claims into collective redress mechanism?
Yes, thank you, Yela. It's very difficult because you mentioned the US cases, the Dutch cases, and yes, I scratch my head, but I cannot think of any EU non-Dutch cases where we got relief, not talking even about damages, but relief as abused individual investors. I would like first to make a disclaimer because I am very honored to be in a panel with many lawyers, but I'm not a lawyer. I am just, yeah, so that's good. And he is also running an association of individual investors, so I feel better. By the way, I wish you good luck because it seems to me you have very good arguments, the ones you listed at the end. But that is Switzerland. That would be something that's not yet the EU, but it's an associate member, so it's a good sign. So why? I didn't know. I don't know if the exact legal term is associate member, but at least they have legal, formal, formal relationships. So why, in fact, it's, the Americans would say is sometimes you don't walk the talk, or you could say it's schizophrenia of public policy makers in Europe, because on the one side you have, at least since 2015, what is presented as a major priority of the European Union, which is the Capital Markets Union. This morning we talked extensively about it and about its, to be nice, quite slow evolution. But at the same time, they recognize publicly that to have a Capital Market Union, you have to have the participation of citizens as individual investors, because they provide by far the majority of funding to the economy. And they also agree that to get more participation, you need trust of these people. And to need trust of these people, you need, I think, at the very least, as a prerequisite, to enforce the law and to enforce the conduct of business laws, including the ones which protect individual investors and their assets. And this is done quite poorly in Europe. If I start with public enforcement, because to go to court is private enforcement, public enforcement is extremely rare in the EU, but I'm sure the lawyers may have counterexamples, hopefully, that the supervisors, the public national supervisors, really sanction the people or the parties or the companies responsible for abusing individual investors. If I take the case of Wirecard, I'm still waiting, because Yela, you talked about auditors, but there were also two supervisors involved, not one, but two in Germany, and I don't know, I haven't seen any sanction. I've seen the chair of one quitting, or leaving, or being politely asked to leave, but apart from that, I didn't see. And it's even more striking when you look now at the ESG issues. For example, the major German fund manager has just been fined $19 million for misreporting the amount of green money it was managing, green funds. Misstating by a very small amount, it had to reduce it by 75%. Tiny correction. But as usual, like in the past, it was not ESG cases, but for Madoff, for example, or I remember the pension fund of Enron, they were fined and they went to jail. If I look at this major fund management in Europe, I'm still waiting for any sanction from the EU authorities. So that's public enforcement. And for private enforcement, yes, we have the Netherlands, but that's not your question. That's not a pan-European framework. And Netherlands was quite effective, Shell, Fortis, etc. But we have, as we said here, we have Wirecard, Volkswagen, we have Airbus, an ESG case. We have less well-known cases, but that also abuse millions of investors. For example, Natixis Bank in France in 2007, 2 million clients abused because they were sold shares on incorrect information reported, and it's not settled. It's been 15 years. So 2020, we get finally a directive on representative actions for collective interests of consumers. It took me time to remember this title. We call it the Collective Redress Directive. So first, it's 2020 was to be implemented by member states by June 2023. So it's a bit early to give an actual impact, but when you read the directive, and in Better Finance as an investor and financial user representative, fought a lot to improve it, consumer organizations as well. Well, first, it's a minimum implementation directive. So if member states think they have to summarize, I'm not a lawyer, as I said, so I'm just summarizing, feel they are meeting the minimum standards, they have nothing to do to change their law. It is opt-in only, and I would like just to say one word about opt-in. By experience, it's extremely hard for us because it's very difficult in many cases to find, identify, and explain and convince the victims, especially in investments and financial services. I remember a case in France for a pension fund. After 10 years, the association of abused pension participants and the lawyers managed to find 7,000 plaintiffs. And already for the lawyer, no collective redress, 7,000 files. Pension fund, extremely technical, extremely difficult to assess the damage, and individual cases every time because it depends on how much you contributed, for how long, at which time, blah, blah, blah. And there were 450,000 participants. We may talk again about, and hope, about Airbus. It's extremely difficult, even for associations of investors to track, find the investors in the Airbus shares, especially in some countries where there was, let's say, to be polite again, minimum publicity by the media on the, although it's a 3.4 billion penalty that they got for bribery. So opt-in is bad. We would have preferred opt-out, and de facto, to look under the control of Q in the Netherlands, it becomes an opt-out procedure. And it is, there are two little good things, and I will tell you about more bad things. Little good thing is that funding is allowed, in principle. So of course, minimum implementation, so there will be gold plating in the member states because, as you said, the funding is a key issue, and as Anatoli said before. And qualified parties are a bit like in the Netherlands, defined in the directive as people, of course, who have no conflict of interest, are not paid for that, but represent the interests of the abused people. The very bad thing, especially for us as representative of investors, is that de facto, and that's also schizophrenia with the capital market union, individuals who invest directly in capital markets are excluded from the scope of the collective redress directive, and we never got even an answer as to why, and telling them, but you have your capital market union actions, we need trust, we need enforcement of investor protection laws, and on the other side, when you have Wirecard, Volkswagen, etc., no, but you cannot do it. So in practice, especially the market abuse rules, European EU-wide market abuse rules, are not listed in the EU rules that can be subject to a collective redress action.
Thank you, Guillaume.
Say more,
and I think, I'm sure you can say more on it. It's not finished yet. But I think you mentioned a very important key point, and that's funding. Funding is a key issue in all of these legal actions. It's also one of the reasons why shareholders in our countries are very, they're very laid back. They don't want to get into cost risks and stuff like that. So my provocative thesis is if you don't have the funding, you will not get justice. I mean, it's really provocative, but I'm interested in your view. Arik, you also had a funder, right?
Yeah, so we decided to offer two kind of possibilities to participate in the class action. One was we asked people, because the question that you asked was interesting, if it's throwing good money after bad money, or is it an investment into your investment? And we saw that a lot of people, they didn't want to deal again with Credit Suisse and to lose even more money, because in Switzerland, people like to invest in national champions, and they some of them they don't sell, so they bought the shares at extremely high prices. So the damage is huge, like 99% in some cases, because people thought it would never happen that Credit Suisse will disappear. And for some of them, it was difficult to invest any further, and we made a calculation. How much will the case cost? How many plaintiffs we think will participate, and how many shares might they represent? So made a calculation, and that's why people now pay 7 cents, 7 Rappen per share in order to participate. However, we saw that a lot of people, as I said, don't want to pay, so we reached out to litigation financiers, and it was difficult to find on such a short notice a financer, because from launching the possibility to participate until the submission of the claim, we only had 4 weeks, and we had no infrastructure, no platform to register. So it took, it was quite of a pressure to find someone, and we were also in talks with someone from Austria, and in the end they rejected. So we were happy that we found private people who said, okay, we want to support this case, and that's why we're going to finance this. But yes, it was difficult.
Eric, I think you also had your experiences with Volkswagen and other cases. Is the thesis right?
I think funders are no charity organizations. So they are looking at financial markets and of the possibility if you can procure a claim within a certain time frame, within a certain success rate, and look at the outcome and the length of the proceedings. So basically, funders, we are talking here about, most of the time they are people out of the financial industry who are willing to invest most of the time a couple of million euros over a period of time, 10 to maybe even longer years, and hope that in the end of all days they are receiving more out of it than they invested. So and this is something why I don't think that the Airbus case is good in the sense of that I'm cheering to it. It's awful, but it sharpens the edges and smoothens it smooths the edges of what we can do in Europe to procure claims, and this reduces the risk for funders being willing to invest in such cases. And since my quick survey just showed that we have a culture of when we are experience a loss out of a fraudulent behavior from companies, then we are more feeling comfortable if some consultants, even lawyers, say like, you know what, don't go for the claim. It takes ages, you will not succeed in the end, just not taking the risk. If I would make out of this a business, I would be a really rich man, because this is literally what investors want to hear when they lost on the stock exchange market or in other investments their money, because we do not have a culture, I think, that says, I got cheated by this guy. I want to see him in jail. I want to get money out of him. And for the people who were auditing him, who were checking him, I'm talking about the Wirecard case, and we do not see this justice. So while we have the culture of not being willing to invest in the procurement of a claim, third-party funder is, in my opinion, the only way how you can get access to justice, because they are willing, but not for every price. So, and we are in a situation in Europe where this all is just developing, and that's why we have to be cautious. But on the other hand, we also should, and this is my last point, referring to what Guillaume said, the procurement of a claim is an asset of a capital market. I think capital markets, which offer investors in the situation when you lose your money, a reasonable and also from the timely perspective, a reasonable way how to go after those who were causing the damage, is definitely an asset of a market. I would be only willing to invest in such a market and not where I have, when something happens, only the depressed possibility to say, well, it happened, so I'm not throwing good money after the bad money. So that's why I think the US is much more effective and successful also as a financial market.
Absolutely, I agree on that. Q, before I come to you, I share your view on the funder. I'm not as sure about the investors, because look at Germany, we have 30,000 investors that were all invested in Wirecard, and they all joined the action. So it's not that they don't want to do anything, they just don't have the possibility and the limited, we have limited possibilities in Germany legally.
Sure, but the 30,000 don't want to pay.
Well, because they don't want to have a cost risk, and that's where we talk about the funding again. So Q, funding is a big issue also for the Airbus case, right?
Yes, it is. But I wanted actually also to link the funding issue to something that that actually came up earlier during this panel discussion, and it's unfortunate that Anatoly already had to catch his plane, because he referred to actually two types of cases in the US, which I think are interesting. One is going after damages, which is essentially what we are all trying to achieve in Europe, and which require litigation funding. I think we all agree on that point. But I think the other interesting thing is he gave that very inspiring example of the 21st Century Fox case, and there actually the claimant, which was an American pension fund, actually sued with the aim to repair governance shortcomings and certain social issues within the company. The lawyers in that case worked on a no cure, no pay basis, and they were actually paid from a part of the settlement outcome, which was actually paid by the insurers to the company, and which had to pay for the governance reparations that were to take place. So the lawyers were paid out of that, which means that even when it comes to if you want to pursue improvements in terms of social situations and governance in a company, you also need a driver, which can be funding, in order to make that happen. We have nothing of that sort in the European Union at the moment. In the Netherlands, you can pursue inquiry proceedings with the Amsterdam Court of Appeal, and then the Amsterdam Court of Appeal can order an investigation into the company, and it can take certain measures, but there's no way in which you can make money out of that as a claimant representative organization. So I think that is something, if the European legislator would put something on the agenda, it would be actually not only reparational, always getting after the money when you have already lost, but it is also about trying to change something which does not necessarily result in the payment of money to those who lost it. So yes, litigation funding, but there should actually be more opportunities for litigation funding, one could say.
Yeah, and we would also need the legal remedies to have more impact on the ESG issues. But in Switzerland, do you have any possibilities to have influence on ESG?
I mean, we just started, but in the first case that we had, for example, there was only after the General Assembly, you had to communicate or to publish the minutes, and there was also only a recommendation when to publish it. So there was no law when you have to publish them. However, there was a limit until when you could go against decisions that have been voted for. So it could be that this deadline has passed, but the minutes haven't been published yet. So that has been changed recently. I don't know how big our contribution was, but we campaigned for this. So I think if you're allowed, you can have an influence, for sure.
Okay, thank you. Before I come to the end of this panel, maybe I look towards you again. I know you're already tired and you're looking forward to the dinner tonight. Any questions from your side? Yes, Gertrude.
So far, we were mainly talking about, so to say, direct claims from shareholders towards the company. Are there any cases in evidence where, for example, holders of bonds or funds or pension rights have claims against, let's say, a fund management company about not pursuing claims against a company for misconduct?
Good question. Who wants to who wants to answer?
Very good question. Very good way of thinking. I don't know. I'm not aware of that. No, it's not public. But I want to flag there is an obligation of every CEO and of every, because one of the cases we are procuring now is the construction cartel. So there is an obligation also from the decision makers of public entities to procure claims, because it's their obligation to do so. So is anyone aware of that happened already? That something that they were suing the management, that they did not go after claims? I have not heard about it.
I would actually say it's even worse. I think most people do not even know that, for instance, the one who's is managing their pension should go after someone. And even if people are directly invested in situations where, for instance, there has been reached a settlement in the US, because that, of course, is settlement Valhalla, even then people are often not informed by their European banks or wealth managers or whatsoever that they can actually pick up money in another jurisdiction. There are initiatives going on in order to remedy that, but that is actually where we currently are.
To complement, I raised that question in the case of the Wirecard case, because Jela said it was a terrible case for German investors, 20 billion market cap vaporized, to take Anatoly's word, in a few weeks. But the shareholders were either direct individual shareholders or not individual, but also a lot of funds, investment funds, pension funds. I asked the question to the BVI, which is the German Federation of Investment Managers. He said, how come you are not doing? Because it's not only German. In fact, as Wirecard was a DAX 30 at that time company, it was in all German equity funds, but also in most European equity funds held not only by Germans, but Italian, French, etc., Spaniards, etc. So why did they sue? because yes, they have a fiduciary duty to do that. Same thing for pension funds. At what point, someone from BVI said, Guillaume, I think one will soon. I was going to say, why not all? So that's a very good point. And in fact, yeah, I think we should look further into that, especially as we've always been quite, how would I say, sensitive to these people, the pension funds, investment funds, because they are called institutional investors, but they are more rightly called, like Professor John Kay says, other people's money. And in fact, in the professional magazines, they are told asset owners, but that's the legal owner. But the one who bears the ownership risks and rewards after costs, etc., is the end investor, the pension participant, or the fund investment shareholder. So thanks for the question.
Yeah, very good question. Yeah, sure.
Yeah, we also have been approached by pension funds if they can participate, because they have the legal obligation to refund the money or request the money. However, for them, they also thought, do we invest further, or to join us, or are we going to do it ourselves, or are we doing anything because we can't argue against the pensioners that we invest or further into the Credit Suisse case. So I only know that 30 claims have been submitted at the court in Zurich. I don't know if it's individuals or pension funds. I know that some are with us, but I can't say how many of the Swiss pension funds have filed a claim themselves.
Yeah, I just wanted to make one point, and that regards to the institutional investors, just like the pension funds. In all the Dutch securities cases that I've seen, the majority of claims and claimants actually consists of institutional investors. So for instance, our Airbus case is backed by approximately 150 institutional investors, and that consists of pension funds, wealth managers, whatever, insurance companies, reinsurers, all from all over the world. And that is actually typical for this type of cases because of the reasons spelled out already in this panel. So please don't take my my words as a critique against the institutional investors, because they are actually very active. But at the same time, there's also a number of the really big institutional investors, is not particularly the word I should use, which actually refuse to take the responsibility and the first step. I'm not mentioning names, but some have been mentioned already.
Too bad. No, but thank you very much. But maybe, Q, I don't want to let you go and close the panel before I have your last estimation of. Now we have this bad judgment in The Hague, I think. It was the court of The Hague. What is your estimation? What does it mean for class actions in the Netherlands in general? Is the door closed now for foreign investors, or can we be still optimistic?
I think it's a temporary hiccup. It's just one judgment out of the many cases that have been pending. It can be appealed. So there are still multiple venues to bring this matter to a relatively good resolve for investors. The law is just in the making, and who are making the law, who are shaping the law? That is us, practitioners, that's the judges, and sometimes it's the legislature intervening. I mean, this is all, we're just in the beginning, and there's hopefully a future ahead.
That's a good last word. I think we learned a lot about the US class actions, which is still the El Dorado for us shareholders and investors, to be honest. We know that there are quite a lot of deficits at EU level, but that's one of the functions of better finance, to really put things forward and to fight for an efficient collective redress system also for investors. And I also agree, for a European capital market union, you need a very efficient private enforcement system and a very efficient public enforcement system. But we are optimists, and that's how I would like to close the panel and say thank you to the panelists for their contributions. Thank you. Just in time.